Could one overlooked checkbox now ruin your entire immigration case? What if your old tweets or memes are now grounds for denial? Or worse, ICE referral? And why are even green card holders being watched more closely than ever? If you're applying for a green card, renewing your work permit, or even just trying to avoid unnecessary risk, these 10 new USCIS rule changes, now fully active as of July, could decide everything before August hits. Stay with me as we unpack what really changed and what you need to do now. One denied? You might be reported to ICE immediately. Let's start with the most serious and underreported shift. In late June, the Department of Homeland Security, DHS, released a new referral memo, quietly instructing USCIS to send more denied cases directly to ICE, Immigration and Customs Enforcement. This isn't just limited to criminal cases anymore. Here's what's now getting flagged for ICE referral: denied asylum applications, denials of adjustment of status for visa overstays, green card rejections involving suspected fraud, prior unauthorized entries or illegal reentries. Since July, multiple immigration law firms have confirmed a spike in referral letters immediately following denial notices. What used to take weeks or even months is now happening within days. While a referral to ICE doesn't guarantee removal, it does raise your risk dramatically, especially for those with prior infractions. Action tip: if your case involves any gray areas like overstays or past visa violations, get legal counsel before August starts. Prevention is cheaper than removal defense. 2. USCIS is watching your social media seriously. This isn't a pilot anymore. As of July 2025, USCIS and the State Department have fully implemented joint social media screening policies. Who is being screened? All F, J, and M visa applicants, H-1B and L-1 visa holders flagged for additional review, adjustment of status applicants undergoing background checks, individuals under national security watch. But it goes beyond looking for obvious threats. Officers are instructed to look for engagement with flagged or banned accounts, posts interpreted as anti-US or anti-government, comments that suggest violent ideology, even political memes or satire that may indicate subversive views. A leaked June 18th internal cable reveals that refusing to provide your social media handles, setting accounts to private, or deleting old posts may now count against you. Pro tip: scrub your social media. Delete controversial posts, untag yourself, and avoid political discussions on public profiles. 3. Marriage interviews now feel like FBI interrogations. Getting a green card through marriage? The bar has been raised. Starting mid-July, USCIS officers are using new training tactics to dig deeper. Instead of asking just how you met or what your rent is, they're now exploring long-term life planning as a couple, joint financial habits, like how you split bills or file taxes, social media history. Do you tag each other? Do your stories match? How you celebrate holidays, religious beliefs, or family traditions. Cases that raise doubts, especially those where the couple married within 3 to 6 months of meeting, are being sent for Stokes interviews, a second-level interrogation where couples are separated and asked detailed questions to catch inconsistencies. Pro tip: practice mock interviews with a trusted immigration consultant. Keep documentation consistent and updated, especially for shared finances. 4. One error equals instant rejection. No mercy policy. If you've been thinking USCIS will just ask for missing documents, think again. Since mid-June, USCIS has returned to a zero-tolerance approach. Even small filing errors now lead to immediate denial, submitting outdated form versions, leaving any required field blank, forgetting to sign, even if it's just your interpreter, uploading low-resolution scans, failing to pay the exact fee. Attorneys nationwide report an increase in Form I-485, I-765, and I-130 rejections due to tiny mistakes that were previously handled with RFEs, requests for evidence. And here's the kicker: no appeal, no warning, and your case may be marked closed without notice. Avoid this. Use the USCIS online form checklist every time. Confirm edition dates. Sign every single line that requires it, even if you're unsure. 5. Green card holders are being monitored online. permanent residents and visa holders aren't off the hook. USCIS has quietly rolled out a secondary monitoring system that targets current LPRs and adjustment applicants for online surveillance. Here's what they're watching for. Online discussions critical of U.S. policies. Engagement with political satire that could be misread as extremist. Joining certain social groups or pages that appear anti-American. Patterns of posting during background checks or pending cases. According to a whistleblowing officer interviewed anonymously, we don't judge political views. We assess potential risks. Even a meme can raise a red flag. This kind of digital profiling can trigger secondary interviews, extended processing delays, or even denial. Heads up, change your privacy settings, avoid political memes, and don't post about your immigration case publicly. 6. Forget the RFE. Medical forms must be filed up front. Quietly enforced as of July 1st, USCIS now requires your Form I-693 medical exam to be submitted with your Form I-485 adjustment of status packet. Previously, you had a 60-day grace period to respond to a request for evidence if the I-693 wasn't included initially. That's gone. Now, if your I-693 is missing, the case will likely be denied outright. No RFE, no grace period. Reminder, always get your exam done by a USCIS designated civil surgeon, and it must be signed within 60 days of filing. 7. Work permit slashed to 6 months. Are you affected? Another cost-burdening shift. Many work permits, EADs, are now being approved for just 6 months, not the usual 12 to 24 months. Affected groups include DACA recipients, adjustment applicants, marriage-based and employment-based, pending asylum seekers in certain states. This policy was hinted at earlier in 2025, but as of July, it's being rolled out more widely at specific field offices. Impact: you'll have to renew more frequently, pay more, and deal with overlapping timelines. So plan ahead. 8. Green card holders, carry ID, or risk arrest. It's an old rule, but it's now actively enforced. Under 8 U.S.C. Section 1304E, all non-citizens over 18 are legally required to carry proof of alien registration at all times. That includes your physical green card, Form I-551. In July alone, multiple LPRs were reportedly stopped near state lines and held in detention until someone could bring their ID. Officers are treating this as a misdemeanor offense that can trigger ICE holds in some cases. Solution: if you don't want to carry the physical card, at least carry a clear photo or digital scan stored securely on your phone or email. 9. Visa Bulletin. Major setbacks for Indian applicants. The July 2025 Visa Bulletin delivered a mixed bag. Family-based categories. F2A, spouses/children of green card holders, still current for most countries. But real-time processing delays mean 10 to 14-month waits in many cases. F4, siblings of U.S. citizens barely moved. Some countries saw slight retrogression. Employment-based, EB3 India, rolled back more than 7 months. A major blow for thousands waiting on approvals. EB2 and EB1, largely stagnant. Don't expect major movement until Q4 or later. Strategy: watch for the August bulletin. We'll be breaking that down as soon as it drops. 10 plus years undocumented? You might qualify for a green card. There's one bright spot. Immigration courts, overwhelmed by their caseloads, are quietly approving more 42B cancellation of removal cases. You may qualify if you've lived in the U.S. continuously for 10 plus years. You have U.S. citizen or LPR spouse, children, or parents. You can prove exceptional and extremely unusual hardship to those relatives. You have a clean criminal record. Legal aid clinics in California and New Jersey reported a spike in successful 42B approvals throughout July. While still difficult, it's a window worth exploring if you meet the criteria. Tip: don't file alone. These cases need deep legal preparation. Final checklist. July 2025 was a game changer. More denials without warning, more digital surveillance, more overlap between USCIS and ICE, and less room for honest mistakes. But for those who stay prepared and vigilant, opportunities like 42B do still exist. The system now rewards accuracy, discipline, and awareness. Before August begins, check your paperwork. Fix your digital footprint. Know your rights at interviews and borders. And if you're unsure, get help now, not later. If this helped, hit like and share it with anyone navigating a green card or visa process. Subscribe to Immiscope. We'll be breaking down the August visa bulletin and new DHS enforcement memos next.